Welcome to your overview of the Real Estate Council of Ontario's Information Guide.
We're Katie and Daniel Steinfeld of On the Block Realty, and we are happy to share this video as a full walkthrough of what you need to know about the guide. This short video is meant to explain the details within the guide in an easy to understand and visual presentation.
As we walk through the guide, make note of any questions you may have and be sure to ask your real estate representative for any additional information or clarification you may need.
Now, why did you receive this guide in the first place?
As a major element of the new legislation governing the real estate profession in Ontario, known as the Trust and Real Estate Services Act, effective December 1st, 2023, any individual who interacts with a real estate agent must first be given this guide before receiving any service or assistance. In addition to receiving this guide, the real estate professional must explain the details of the guide as well.
Interacting with a real estate agent representing their own client, perhaps someone selling their property, or you may be considering receiving services from the real estate agent yourself. In either case, the review and understanding of this guide is extremely important to prepare you for the responsibilities of all parties in different types of interactions in real estate, whether buying, selling, or leasing.
This guide will explain the relationships between real estate professionals and consumers, the paperwork involved, the risks of representing yourself, and different scenarios that could occur, such as multiple representation, when a single agent represents both parties on both sides of a transaction. Finally, details about how real estate professionals are held accountable to these rules are explained as well.
This guide is meant to enhance your understanding of the interactions and responsibilities you may have in a real estate transaction. It is not, however, meant to replace independent legal advice.
So why work with a real estate agent?
In Ontario, working with a real estate agent or broker means you are protected by an individual with extensive required education, who is insured for both funds held and professional liability, and who is bound to the profession's code of ethics.
The advice and knowledge a real estate agent provides a client is the most important element that a consumer can expect. Real estate transactions can be stressful and complicated, and it's the job of a real estate agent to make the process more comfortable, easy to navigate, and focus on the specific objectives of the client.
Take a moment to review some of the specific tasks and responsibilities a real estate agent can take on with their client. For a seller, they can advise you on market conditions and the best strategy to attract buyers and get the best price for your home, market or advertise your home, including arranging photographs, videos, and virtual tours, provide referrals to other professionals you'll need like a lawyer or home staging company, arrange and attend home inspections and appraisals, arrange showings for interested buyers, advise you on how to handle competing offers, sharing the content of competing offers and other aspects of the transaction, vet offers and potential buyers to ensure they can afford to buy your property, negotiate with buyers to achieve the best results, price, and terms for you, and guide you through paperwork and closing the transaction successfully.
If you are in the process of buying a property, some of the services a real estate agent can provide may include assisting you with getting pre-approvals for financing so you know how much you can afford, making you aware of any tax exemptions you might be eligible for, gathering and sharing information about neighborhoods and homes to meet your requirements and arranging to show you homes you'd like to see, making inquiries about zoning, permitted property use, or other aspects of the home, advising you on the best approach in competing offer situations and how to protect your offer information, negotiating with sellers to achieve the best results, price, and terms for you, guiding you through paperwork and closing the transaction successfully, and providing referrals to other professionals you may need, for example, home inspectors, lawyers, or contractors.
It doesn't end there, though, when it comes to an agent's responsibilities. Both the agent and their brokerage owe their clients a protection of the client's interests. Advice and guidance are focused with the best interests of the client at the heart of it all.
Any information that could have an impact on decisions you make with respect to a transaction must be disclosed to you by your agent as well.
Your information is prohibited from being shared with anyone who is not a part of the representation agreement. That could mean all members of the brokerage if you are subject to a brokerage representation, or be subject to confidentiality to your designated representative alone, which we will discuss later in the guide. In any case, your confidential information is protected forever by virtue of your client relationship, unless law requires a disclosure or you give consent to disclose information.
Finally, you're protected from situations where your real estate agent would be in a conflict of interest that could affect their ability to act in your best interest unless you agree to continue working with them despite a conflict. Any conflict must be disclosed to you immediately.
While real estate professionals have a great deal of responsibility to you as their client, there are also responsibilities clients have to their real estate agents for the benefit of all parties in the relationship.
Client must be honest and clear about what they need and clarify any information that would be relevant to the transaction. You might have certain non-starters or requirements in your search as a buyer, and it is incumbent on you to tell your agent to avoid unnecessary time or wasted resources.
You must respond to questions from your agent honestly and quickly.
You need to fully understand the terms of your agreement with the brokerage, and the agent must explain fully those details to you, and
you must pay any fees agreed upon in the agreement, even if a deal fails to complete because of your own negligence or default. We will discuss remuneration further later in this guide.
To this point, we have discussed the entitlements and responsibilities you have as a client of a brokerage in a real estate transaction. Whereas there are compelling benefits to getting representation from a real estate agent, there may be instances where an individual does not want the services of a real estate professional. In these situations, the individual is referred to as a self-represented party. The rights and the responsibilities afforded to a self-represented party are quite different, and it is important to understand them before deciding to represent yourself.
Typically, if one decides to represent themselves in a real estate transaction, they will be dealing with a seller or buyer who in fact has representation of a real estate professional on the other side of the transaction. This means all the advice and guidance of a professional are solely provided to the person with whom they are dealing. This could put you at a considerable disadvantage in several key elements of the process.
If you choose to be self-represented, all functions and steps of the real estate process are your own responsibility. This includes preparing paperwork, determining value of a property, establishing the offer price, or protecting yourself with conditions, clauses, or other important details. You will also need to know specifically what to look for in a property or how best to negotiate terms. Your best interests are not the responsibility of a real estate agent, and no advice or guidance can be provided to you when you represent yourself.
A real estate agent is working for their client and representing their best interests. So no matter your interaction, if you're representing yourself and dealing with an agent of another party, their duty is to their own client. This means anything you say can be shared with their client, and anything they do for you can only be assistance that would be to the benefit of their own client. For example, a seller's agent may provide access to a viewing of their listed property, as that helps their client get potential interest.
An agent cannot provide a self-represented party with any service, opinion, or advice. They cannot exercise their judgment or skill in any way for a non-client, and they are also not permitted to direct your decision on whether or not to represent yourself. They can only share the facts contained in this guide and any other information that could be in the best interest of their own client.
Additional form, the information and disclosure of self-represented party must be provided and explained to you before any assistance can be provided. You must acknowledge that you understand what it means to be a self-represented party.
You are able to change your mind from being self-represented if you choose at any time. We will discuss the contract process if you do decide to be the client of a real estate brokerage next.
When you decide to work with a real estate brokerage and create a client relationship, you must sign a representation agreement. This agreement is the contract between you and the brokerage and lays out all the terms and responsibilities of the parties in the contract.
If you are a seller, you will sign a listing agreement, and if you're a buyer, you will sign a buyer representation agreement. Similar representation agreements are required if you are a landlord or a tenant in a lease transaction.
One important change to the way a brokerage will represent you is the difference between designated representation and brokerage representation. A brokerage can elect to represent its clients using these two approaches, but it's important that you understand the difference between the two as they impact the way your interests are represented and specifically who your client relationship is with.
In brokerage representation, you are a client of the entire brokerage, and all members of the brokerage must protect your best interest. This means information may flow freely through a brokerage, but all agents and staff owe the same duty to you as a client.
Brokerages that choose designated representation will designate one agent specifically to represent each client separately. This means that your agent must represent your best interests in all decisions, but other members of the brokerage simply owe you fair and impartial treatment. Your information is confidential to only your agent. However, the brokerage may still oversee the relationship and owes a duty of care to you as well.
In brokerage representation, there is a greater possibility of multiple representation, as any agent from the same brokerage would have the same client relationship with you. This will be discussed later. In designated representation, agents from the same brokerage could maintain independent client relationships with clients on each side of a transaction with no reduction in service.
Representation agreement has several required elements you should look for and understand before you sign.
If the brokerage is a designated representation brokerage, you'll need to see the name of your designated representative on the agreement. Note that there can be more than one individual designated on the agreement.
The scope of the agreement is also required.
This means that the specific property being sold is to be identified in a listing agreement, or the details surrounding the specific area or details of properties being looked for in a buyer or tenant search. Details and clarity are very important, so if the scope is not clear or accurate, make sure to question and adjust as necessary.
Your representation agreement must also lay out the services to be provided to you. While there is no standard set of services, you should be comfortable in understanding what is being listed and ask questions to clarify anything that you need explained or feel is missing. Different brokerages and agents offer different services, and different transactions may merit different variations of the best and most fitting set of services.
It's important to note that services are listed with intent to provide, but there could be circumstances where a transaction is completed quicker than expected, which could lead to some of the services not being performed. For example, open houses may be listed as a service to be provided, but if a home sells before the open house is planned, such a service would no longer be necessary.
Also necessary in any representation agreement is clear explanation of how the payment terms are to work. In the case of a buyer or seller agreement, the details of remuneration are equally necessary. Several important pieces of information are required.
You must see the amount that is agreed you will pay the brokerage. This goes for both buyers and sellers. As a seller, you'll need to see how you may be compensating the buyer for their brokerage fees, and conversely, as a buyer, how you are expected to compensate your brokerage depending on whether a seller will cover some, all, or none of your fees.
In all cases, clear explanation of how compensation may change in the event of multiple representation is required as well. In summary, all amounts payable to the brokerage, including how those amounts may change in different circumstances, must be explained clearly.
The representation agreement must also have clear termination provisions provided. The circumstances that could lead to termination must be detailed, as well as how the termination process would work, inclusive of any potential costs or penalties.
Two specific situations should be addressed with respect to the appropriate circumstances that would follow. One is multiple representation. In the event a client does not agree to multiple representation, there may be the possibility of termination or the assignment of the client to another designated representative. This should be explained fully.
Another scenario that should be addressed is a situation where your designated representative is no longer available, perhaps for a vacation or because they leave the brokerage entirely. What happens in this situation should be clearly explained.
In addition to termination details, the expiry date of the contract should be clear on the first page of the agreement as well. There is no stipulated or required minimum or maximum amount of time before a deal expires.
Final element you may see on an agreement is a holdover clause. This is a period of time following the expiry of the agreement where you may still be responsible to compensate the brokerage should you enter into a purchase and sale agreement within the holdover period. For example, if there's a 30-day holdover clause, you may still have responsibilities to the brokerage even if you sell or buy a property a few weeks after the agreement has expired. This clause is meant to protect the brokerage, and it should be discussed and understood.
I've mentioned the concept of multiple representation a few times throughout this video. Simply put, multiple representation is when a designated representative or brokerage represents more than one client with competing interests in the same transaction. This may be a buyer and a seller, or competing offers in the same transaction.
In designated representation, multiple representation occurs when the same designated representative is representing more than one client with competing interests. And in brokerage representation, that definition expands to when the brokerage itself represents two or more clients with competing interests in the same transaction.
Multiple representation cannot occur without the written consent of all clients involved. There are risks to consider before consenting to multiple representation.
Because a designated representative must protect your best interests as a client, having two clients with competing interests limits the allowable service of that representative. In multiple representation, the designated representative or brokerage must treat each client impartially and objectively. They cannot promote or protect the interests of one client over the other, and they cannot offer advice to help aid the decision if it would compromise the interests of the competing party, such as the advice on price to offer or accept.
It's important to understand the limitations and details of multiple representation before agreeing to it. Your representative must explain how their responsibilities will change under multiple representation, including changes to service and potentially changes to compensation owing.
No further steps can be taken until details are communicated to all parties to the transaction and all clients have agreed whether or not multiple representation is to proceed. You have the right to withhold consent to multiple representation, and a brokerage or designated representative should have alternative options if you do not consent.
Another new element to the Trust in Real Estate Services Act is the concept of open offers. Historically, only the number of competing offers had been detailed and could be shared with competing buyers in a transaction. Under the new regulations, a seller can elect to disclose the substance of competing offers to all parties making an offer. There are some key points to note here.
There's no standard amount of information to disclose or not disclose. A seller may opt to disclose the price of competing offers, closing dates, conditions, deposit amounts, or a combination thereof.
Personal or identifying information cannot be disclosed.
The decision to disclose can come at any time in the sales process. It is possible that a closed offer process could open up if the seller decides. Buyers should be prepared for this possibility.
Any information that is disclosed must be disclosed to all offering parties.
If you do not wish to have the contents of your offer shared, you can discuss options with your agent to avoid having the content shared.
If you have any concerns about the conduct of a registered real estate agent, or if you believe an unregistered agent is conducting themselves as an agent, you have steps you can take to address this issue.
First, contact your brokerage. You can identify the contact information of the broker of record by using RECO's public register. Many complaints or disputes can be addressed through this approach.
Should you wish to file a formal complaint about a brokerage or real estate agent, you may visit the complaints section of the RECO website for details on the process. RECO will review all complaints and determine the next steps in their follow-up.
More information about TRESA and the buying and selling process can be found at the RECO website, or for the detail of the new legislation, look up the Trust in Real Estate Services Act 2002 on the Ontario website. All links can be found in the electronic copy of this information guide.
Once you've reviewed this guide and you are comfortable with your understanding, you should fill out the acknowledgement section with the relevant details. If you are sent the guide electronically, you can fill it out on your computer or device, whereas if you have a hard copy, you can fill it out manually. Your real estate agent and brokerage will keep the acknowledgement on file to validate that the guide has been explained to you.
Thank you for taking the time to review this RECO information guide.
As always, if you have any questions about the content of this guide or the real estate process in general, make sure to speak to your real estate representative to get the comfort you need. The new regulations and this guide are in place to protect you, the consumer, and an emphasis has been placed on clarity and understanding. We hope this review was informative and helpful.